Good afternoon and welcome to this Farrar's Building seminar on contractual indemnities. It's our first seminar since our PI conference last month, so it's great to get these webinars up and running, and it's great to see so many of you logged on for what's a slightly niche topic, but one that's no doubt quite important in a lot of our practices. Just a little bit about me. My name's Tom Emslie-Smith, and I am a civil practitioner here at Farrar's Building. I specialise in personal injury and property damage, as well as insurance and clinical negligence. So the reason for this seminar really is that, as is no doubt the case in a lot of your practices as well, a lot of the disputes, the claims in this area, are claims where one of the defendants, one of the clients, is one of several companies in a contractual chain, and there's a contractual indemnity clause between at least one of those companies. And if you're acting for one of those clients, it's a question of what you should be advising them, what kind of arguments there are in terms of who should pay and who might avoid paying, notwithstanding one of these contractual indemnity clauses. So what I want to do in this seminar is to set out an approach to these kinds of questions. So by way of overview, we're going to look at the principles of construction as they would apply to contractual indemnity clauses. We're then going to look at the question of scope, what kind of things fall within the coverage of an indemnity clause and what might fall outside. And then we're going to look at a worked example to see how some of those principles would apply to a factual scenario. And then finally, I'm going to look at a line of authorities that is really important to be aware of if you deal with these kinds of disputes, which covers what's called the Canada Steamship Principle. So by way of introduction, as I'm sure a lot of you will know, contractual indemnities are most commonly contained in particular types of disputes. The classic one, I suppose, would be claims arising out of construction sites. So it's very common for construction contractors to agree to indemnify one or other of the contractors higher up the chain. And indeed, the standard form JCT construction contracts will invariably contain such a form of indemnity. But they also apply in a range of other disputes involving contractors. Very often, if you're acting for a commercial landlord, there will be a contractual indemnity if they contract with another company to perform a task such as managing a block of flats or something like that. You would often see indemnity clauses in contracts for hire. So if someone's hiring equipment, it's quite often they might agree to indemnify the hire company against any damage or claims while they're using that equipment. But conversely, if it's a commercial client who's hiring, they might have standard terms where the hire company agrees to indemnify them against any claims that arise from defects with their equipment. And then beyond that, there's a range of situations where if someone's contracted to provide services, be it transport or storage, or professional services, where they might agree to indemnify someone higher up the chain. And so the common scenario will be that the claimant selects which defendant of several they wish to sue, probably against the person they've got the strongest case and the strongest cause of action, or they may bring in a number of defendants to cover all bases. And then one of the parties will commonly bring in another party or bring a claim by way of Part 20 of the CPR. And if you're acting for a party that's lower down in the contractual chain, the question you'll be wanting to consider is whether there is any way of resisting a claim under an indemnity clause. there'll be three causes of action that you see in one of these multi-party claims in the Part 20 claim. The first is a claim for contribution under Section 1 of the Civil Liability Contributions Act. That's a straightforward contribution claim. Second, you might see is a breach of contract claim, and that will commonly be under Section 13 of the Supply of Goods and Services Act 1982, i.e. the implied duty of reasonable care and skill in the performance of services under a contract for services, or it may be under an express term that provides for something similar. But then the third type of claim, and the claim we're considering in this webinar, is a claim for indemnity under a contractual indemnity clause. The advantages of the third cause of action, if you have the benefit of one of these indemnity clauses, are threefold, really. The first is that if you are the indemnified party and the losses come within the responsibility to indemnify under one of these clauses, then generally you'd be entitled to 100% of the losses. That's usually how they're drafted. So you don't have to worry about apportionment of contribution as you would in a claim under the Civil Liabilities Contribution Act, or anything to do with contributory negligence or anything of that nature. The second advantage is that contractual indemnity clauses are often broader in scope than, for example, a duty of reasonable care and skill. So there can be scenarios where the party who isn't at fault still has to pay the losses that the party higher up the chain has incurred, regardless of whether their lack of reasonable care and skill was actually the cause of those losses. If the clause is drafted in such a way, then it can cover a wider category of losses than that they'd be liable for under a duty of reasonable care and skill. And the third advantage is very often if there's a strong and clear case that a party is going to be liable to indemnify another party, the indemnifier might be willing to take over conduct of the litigation. And that can save one of the parties, the party who is entitled to the benefit of it, at the expense of continuing with the litigation, and they would free themselves for any risk that they'd have to pay anything at the outset, at the end. So before we look at the principles that we'll be considering today, let's set out an example based on a pretty common kind of claim that you may deal with on a regular basis. We've got Acme Construction Company. They're the main contractor and they're the occupier of a building site. BB Builders are contracted by Acme to undertake building works for one of the construction phases. So they're perhaps also an occupier at that time, and they'll have various statutory duties, no doubt, in terms of how they manage and set about their business and for the health and safety on the site. And let's assume there's various other companies and workers that are on site. So it's not just these two parties. Mr. E. Fudd, who's a third party, he doesn't work for either of these companies, sustains injury by tripping on an upturned plank of wood. The wooden plank was laid by BB Builders, but no one knows when it was turned up, and no one knows who was responsible for leaving it in that way. So this isn't a dispute where there's a clear case to say whose lack of care and skill has meant that wood has been left in a turned up position. So it's difficult to identify the party who's at fault on ordinary principles. So Mr. Fudd has chosen to sue Acme, and let's assume that Acme is liable under some or other statutory duty. Clause 7 of the contract between Acme and BB Builders says, BB Builders shall indemnify Acme against any losses, claims, or liabilities arising out of performance of the services. So a very simply drafted contractual indemnity clause. And the question that we all want to know the answer to is, can Acme pass on their liability to BB Builders on these facts? Now, to get to the answer to that question, we're going to have to consider the construction of the term. By construction, we mean the process of discerning the meaning and the legal effect of a contractual provision and its application to the facts of a test. Now, this isn't a webinar on contractual construction, so I don't have time to go through all the principles that are relevant, but it's worth reminding ourselves of the basics of contractual construction, and they're quite helpfully set out in this in this phrase from Lukoil, Asia Pacific and Ocean Tankers. What was said by the High Court in that case was that the court's task is to ascertain the objective meaning of the language which parties have chosen in which to express their agreement. The court must consider the language used and ascertain what a reasonable person, that is, a person who has all the background knowledge which would reasonably have been available to the parties in the situation in which they were in at the time of the contract, would have understood the parties to have meant. So it's an objective exercise. You're looking at the meaning of the words, but it's what the meaning would appear to a reasonable person. The parties' subjective understandings of the terms are irrelevant. It's an objective exercise, but it's a reasonable person with the background knowledge that the parties would have had. So the court can look to the outside factual matrix or the background against which the contract was concluded to shed light on what the terms might mean in that context. The citation goes on. If there are two possible constructions, then the court is entitled to prefer the construction which is consistent with business common sense and to reject others. So if the court is faced with two competing interpretations of the same provision, they're entitled to consider what the commercial logic of the contractual terms is supposed to be. Put very simply, when the court is looking at the meaning of the words used in a contractual provision, they're trying to discern the meaning by reference to the context of that contractual provision. And that involves two aspects. Firstly, the internal context. So the court's going to look at the other terms in the contract and the overall contractual scheme and to consider the logic of this particular term when looked alongside the other relevant provisions in the contract. But they're also going to look at the external context, which has been described in the cases as the contractual background or the surrounding circumstances or the factual matrix. And these are things other than the sort of black ink letter of the text. It's surrounding facts that might shed light on what the parties actually intended the effect of the contract to be. And that's admissible to discern the meaning of the contractual provisions. Subject, of course, to the exclusion, the well-established exclusion of pre-contract negotiations between the parties, which are inadmissible in terms of construction. So in practice, when the court conducts this exercise, they have a set of tools, a set of interpretive techniques that it's going to apply to the facts of each case. And over time, in the authorities, you see courts applying particular approaches, particular sets of tools, particular principles or interpretative choices to particular types of case. And we can call these standards of construction. Now, two standards of construction have historically been applied to contractual indemnity clauses and are well worth being aware of when you're dealing with these kinds of provisions. The first is strict construction. What that means is essentially the courts have historically been reluctant to extend the scope of indemnity clauses any wider than is necessary. Because essentially, if you are the indemnifying party and you are signing a contract where you agree to pay the indemnified party for things that, on ordinary common law principles, you wouldn't ordinarily be liable for. What that means is that the courts have often been reluctant to construe indemnity clauses any wider than is necessary. So you often see courts adopting quite a narrow and quite a literal interpretation of the words and the phrases within an indemnity clause or an exclusion clause. And on the slide, we have two of the classic examples of strict construction. So the first is Lowery and Vickers Armstrong. In that case, you had a gas engineer who turned up to a house to investigate a leaking gas main. The gas had leaked under the floorboards from a worn-out pipe. And he was doing his job with a lit torch, and he stamped out the torch on the floorboards, and the floorboards exploded, causing him injury. Now, the consumers were under the contract for gas supply, agreed to indemnify the gas board for injuries arising directly or indirectly out of the supply of gas under the terms of this agreement. And what the court held was that in these facts, the consumer was not liable to indemnify the gas board under that provision, because they held that the leak occurred externally, so when it was still in the supply pipe and before it passed through the meter. So they held that didn't constitute directly or indirectly out of the supply of gas. Another important feature in that case was that the gas board was not to be construed as being indemnified against its own negligence, and we'll see more on that later. The second example of strict construction is City of Manchester and Fram Gerard. In that case, there were several contractors building an abattoir for the City of Manchester. And essentially the materials they used polluted the meat. So the City of Manchester were being sued by all the angry meat owners. And the indemnity clause with one of the contractors said that they were to indemnify for liabilities arising out of execution of works, provided they were due to the negligence or default of the contractor, his servants or agents, or any subcontractor. Now, the negligence was on the part not of a subcontractor, but of a subcontractor. And the court held that subcontractors are not covered by this provision. It only goes as far as the subcontractor. So you can see quite a literal approach being applied to that particular provision. And that's an example of the court not wanting to expand it any more than it has to be. And making these sorts of interpretative choices against the party that wishes to rely on it. The second standard of construction to have in mind is what we call commercial construction. And this is what you see in a lot of the more recent cases, because modern authorities have shown a greater tendency towards aiming to give effect to the underlying commercial purpose of an agreement. So they're more likely to look at the external context, the background facts against which the contract was concluded. And courts these days would be more reluctant to arrive at the kind of strained constructions that you might get if you're basing your interpretation on technical legal rules or grammatical rules of construction. But it's worth bearing in mind that the principles we've looked at with regard to strict construction might still be relevant in the modern context. Because where for example, an indemnity is said to modify or displace legal rights that the indemnifying party might otherwise have, or where the indemnified party is seeking to make the indemnifier pay for losses that it's caused by its own negligence, the court might be willing to conclude that that can't have been what the parties intended the effect of the contractual provision to be. And so they might have recourse to a strict construction against the party that's seeking to rely on a more broad effect of the contractual provision. So strict construction still does have a role in the modern context when you're considering the commercial effect of the agreement. So then, how do those principles of construction actually help us when we're looking at a contractual indemnity clause? Well, in most cases, the question really is one of the scope of the indemnity clause. It's a question really of which losses, which acts, which circumstances are covered by this clause and what falls outside of it. Most express indemnity provisions employ this structure. So first you have a list of types of harm or loss. So you might see words like actions, demands, claims, liabilities. You then have a causal or connective factor. So things like caused by, arising out of, in connection with. And then you have the activating or the triggering event or circumstances. So that could be a specific event, for example, the negligence or the breach of contract by the indemnifier, or it could just be a general context, for example, the performance of the services or the agency relationship. So if we go back to the example that we were setting out at the beginning of the webinar, do you remember our contract between Acme and BB Builders had that structure? So it says BB Builders shall indemnify Acme against any losses, claims, or liabilities. That's the type of harm or loss. Arising out of, that's the causal or connective factor. Performance of the services. That's the activating or triggering event or circumstances. Now, in personal injury or property damage claims, the loss will often quite obviously fall within the scope of the contractual indemnity clause, and that's because most indemnities are drafted to be wide enough to cover property damage and personal injury type claims, because those are the most common types of claims that will be in view. So what we're going to do is we're going to focus on the middle of these three parts, which is the causal and the connective factor. Now, in most tort or breach of contract claims, causation is usually answered with reference to a simple question, which is the but-for question. And that's a legal test, and it will give you a straightforward answer. Would the injury have occurred but for the negligence? If yes, then there's a complete cause of action. If no, then the claim fails. Sorry, the other way around. But it works differently in terms of when you're looking at an indemnity clause, because the standard of causation is a question of construction of the contractual language. And so there's no general standard of causation which is presumed to apply to these non-insurance indemnity clauses. So it might be that on a construction of the contractual language, the but-for test is applicable, but that's not necessarily the case. Similarly, in insurance indemnity clauses, proximate causation is generally presumed to be the standard of causation, but that's not the case in non-insurance indemnities. It all depends on how you construct the particular provision at hand and how it applies to particular facts. The second point to note is that an event can satisfy the causal or the connective element without being the sole cause of the loss. So it could be sufficient that it's a cause of the loss, or if it's the efficient cause or a material contribution type argument might be sufficient. And that is significant because it could mean that the indemnifying party is liable for 100% of the loss, even though there are multiple different causes of the damage, and even though one of the causes might be the role of the party that's seeking indemnity. And we'll look at that in a bit more detail later. So let's have a look at some examples of cases where the causal or the connective factor has not been made out. And this might give you an idea of the sorts of arguments that might be raised in respect of a party who's said to be liable under a contractual indemnity clauses. Firstly, the loss caused by the loss might be caused by an antecedent event or a pre-existing circumstance, so something that occurs prior to the action that's in scope. A classic example of that is the Lindenhall case. This was a case at the end of World War II. There was a ship being towed, and the defendants owned the dock the ship was being towed to. A few hours previously, a mine had been dropped in an air raid, and the ship got towed into the dockyard, and the mine exploded, causing damage to the ship and everything that was inside it. And the owner of the ship sued the dockyard, and it was found that the dockyard was negligent. But the dockyard relied on an exclusion clause. That exclusion clause was held not to exclude liability for the damage because it wasn't damage arising in the course of and in connection with the towage. Now, on one view, you can see why they argued that it was damage in connection with the towage, because it happened while the towage was still taking place. But what the court said is the loss was actually caused by the prior negligence of the defendant, presumably in not removing the mine from their dockyard. And so the towage was really just an event that happened afterwards as part of the factual matrix. And so that exclusion clause didn't operate to exclude the liability for the negligence. A second argument that we see in the cases is that the event or the circumstances were just an occasion for the loss. They weren't the actual cause of the loss as required by the contractual provision. So in Great Western Railway and J. Durnford and Sons, you had a lorry company that had been granted a license for the use of a gangway by the railway company. And the lorry company, when signing up for that license, agreed to be liable to indemnify the railway company for liabilities arising out of or in connection with the existence or user of the said gangway. So that's that's drafted pretty broadly, the existence or user of the gangway. But this is how the court approached it. So the lorry was on the gangway, and it hit a rock that had been shunted by the defendant while it was doing its shunting operations. Now, the accident wouldn't have happened but for the existence or user of the gangway. So you might think it's a fairly simple case that's within the indemnity clause, but you'd be wrong. In fact, what the court said was that the existence of the gangway was just an occasion for the loss, rather than the true cause of the loss. And so this clause didn't exclude the defendant's liability on these particular facts. What the court was looking for when it construed the terms arising out of or in connection with the existence or use of the gangway was some closer connection between the gangway itself, perhaps its condition, and the cause of the loss, not just the fact that the lorry happened to be on the gangway at the time. in reaching that conclusion, the court also considered the commercial purpose of this license agreement. So if it was to be construed as broadly as the defendant contended for, then the lorry company would only be able to use the gangway when the defendant train company had stopped its shunting operations, and the court held that that couldn't have been the purpose of the contract. So that's an example of commercial construction as early as the 1920s. And then the third kind of argument you might see in some of the cases is that there was an intervening event between the indemnifying party's actions and the loss. So if the loss actually arises through an act of negligence on the part of the indemnifying party, that might be an intervening event that intervenes between the liability to indemnify and the loss. And also, if unreasonable settlements can sometimes fall into this category. So if a party is required to indemnify another party in respect of settlements for claims, if they were entered into unreasonably, that might be an intervening event that prevents reliance on an indemnity clause. So looking again at our worked example and working some of these principles through, just to remind us of the facts, we had Acme Construction Company, the main contractor and the occupier, BB Builders, who are contracted to undertake building works for one of the construction phases, and then you have various other people on the site. And Mr. Fudd has sustained an injury by tripping on the upturned plank of wood. And if you remember, it was laid by BB Builders, but no one knew who turned it up or when that happened. So it's difficult to identify the party who's at fault for leaving it in this condition. Mr. Fudd has sued Acme, and we want to know whether Acme can pass on its liability to BB Builders under this clause. BB Builders shall indemnify Acme against any losses, claims, or liabilities arising out of performance of the services. So Acme is the party that's relying on this clause, and so Acme is going to want to argue for as broad a construction as it can get away with. So Acme is going to argue that performance of the services is describing the general circumstances where BB Builders is undertaking works inside. So really it's talking about the period of time where BB Builders is doing those services. And you might appeal to the fact that in that time the premises are under their control and they're responsible for abating any dangers. And they would say that liabilities arising out of it is satisfied because Acme is liable for Mr. Duck's injuries. So Mr. Duck has been injured. They've had to pay him. And that's what's in view by this phrase, liabilities arising out of the performance of the services. If we contrast that with BB Builders' interpretation of these provisions, they're going to construe these words much more narrowly than Acme has been construing them. And they want to rely on some of the principles of strict construction that we saw. They'd want to say that Acme is the party relying on this indemnity clause, and so they should have any ambiguity resolved against them. And so what they say is that performance of the services is not just talking about the time period where they're on site doing the services. What it's referring to are actual acts or omissions of BB Builders when they're doing the services. And they say that liabilities arising out of is not satisfied because Acme has to show that they are liable because of things that were done or not done by BB Builders. So do you see we're looking at the actual quality and the kind of liability of Acme, not just the fact that they've had to pay out a claim that's been brought. So you can see two different interpretations. One is construing the words more broadly, and the other is construing the words more narrowly. And the court's going to look at the factual matrix, the logic of the term within the context of the other contractual provisions, and it's going to decide which argument makes most sense and which it prefers. So that was a scenario where it was difficult to put your finger on who exactly was at fault for causing this upturned wood to be left lying around. What would happen, though, if BB builders were responsible for inspecting the site and abating the danger, but we have a different scenario because employees of Acme can be shown to have left the wooden plank upturned. So we have this contractual provision, which at face value is requiring BB builders to pay for any losses that Acme have sustained, have incurred. But actually, the loss arose due to Acme's negligence, and it was Acme's fault in the first place. Would Acme still be able to pass on their liability to BB builders? And this is quite a common scenario because, for example, on a construction site, you'll have multiple different layers of statutory duties and responsibilities. You'll have multiple different occupiers, all of whom owe duties under the 1957 Act. And there's often a basis to say that many of the parties in the contractual chain have breached certain duties. Some of those breaches of duties will simply be failures to abate the danger that's been caused by someone else. But some of the breaches of duties will be positive acts or more serious omissions that they've done. And there might be multiple different bases to say that parties are at fault at the same time. So how does that come to bear on the interpretation of a contractual indemnity provision? And here it's really important to have a knowledge of what we call the Canada steamship principle. Put in very simple terms, what the Canada steamship principle outlines is that the court is going to be very reluctant to conclude that the effect of a contractual indemnity provision is to render someone liable for losses that were caused by someone else's negligence. So if the party relying on the indemnity clause is wanting the indemnifying party to pay for something that was caused by their own negligence or fault, it's going to require very clear language for the court to give effect to the provision in that way. So this is where it all started. Canada Steamship Lines and the King, it's a 1952 case. On the 18th of November 1940, the Crown leased a shed to a shipping company for storing freight. The Crown was responsible for maintaining the shed, and on the 5th of May 1944, an employee of the Crown was repairing the shed using an oxyacetylene torch. He set the shed on fire, and the shed and all its contents were engulfed in flames and destroyed. Now, you might think that that's a pretty clear case where the Crown has to pay the freight company and the owners of the goods in the shed, but these were different times, apparently, because what the Crown did was they relied on Clause 7 as relieving them from a liability for damage to the shipping company's property, because that said, the lessee shall not have any claim against the lessor for damage to the said shed or to any goods placed in the said shed. And to add insult to injury, not only did they avoid liability for paying for the goods that had been destroyed through their negligence, they also attempted to claim an indemnity against claims by the owners of the goods which had been destroyed by the fire, because there was a contractual indemnity clause contained within the lease. So if you can imagine the Crown behaving like that these days, you'd hope it's a little less likely. What the court said on that occasion was set out by Lord Morton of Henryton. And here the Canada steamship principle is set out in rather formal legal terms. So let's work through it. He said, if the clause contains language which expressly exempts the indemnified party from the consequences of its own negligence, effect must be given to that provision. So if it's clear, then that's what the contract says, and you have to give effect to the intentions of the parties. However, if it's not clear, if there's no express reference to negligence, the court must consider whether the words used are wide enough in their ordinary meaning to cover negligence on the part of the indemnified party. If a doubt arises at this point, it must be resolved against them. Now, you do see quite widely drafted provisions in a lot of clauses. For example, any claim howsoever incurred, language like that. So if the words are wide enough, the court needs to consider whether the head of damage could be based on any other ground than the indemnified's negligence. And if it can be based on a ground other than the indemnified party's negligence, then essentially that means that the court will assume that the party did not intend to exempt the indemnified party from the consequences of its own negligence. The point was made much clearer in this later case of Walters and Wesso. So here's what the court said. It's now well established that if a person obtains an indemnity against the consequences of certain acts, the indemnity is not to be construed so as to include the consequences of his own negligence, unless those consequences are covered either expressly or by necessary implication. They're covered by necessary implication if there's no other subject matter upon which the indemnity could operate. And then the court went on to give a rationale for that principle of construction. It said, like most rules of construction, this one depends upon the presumed intention of the parties. It's thought to be so unlikely that one man would agree to indemnify another man for the consequences of that other's own negligence, that he's presumed not to intend to do so unless it's done by express words or necessary implications. So I hope you understand the principle. If a party in a contractual chain has negligently caused damage and it's seeking to require another party lower down the contractual chain to indemnify it for those losses, ordinarily the court will not hold that there is a liability to indemnify them for losses caused by their own negligence, unless there is a very clear provision in the contract that is the effect of the provision. So let's look at a couple of cases where we see how that principle has been put into practice. First one that's helpful to look at is Sims and Foster Wheeler Limited. This was a personal injury case involving multiple different defendants in a construction site type scenario. So you had the main contractor who was tasked with constructing a reactor for Esso Petroleum. The main contractor engaged a subcontractor, and their job was to carry out work to the interior walls of the reactor. The subcontractor then engaged a subcontractor, so let's call them CG, to spray gunite onto the walls. So CG were spraying the gunite, and they lowered a circular staging platform into the reactor. And they sprayed the gunite up to a height of 20 feet. And when they got there, they stopped to let the main contractor install what was called a shroud ring at 20 feet so that they can continue up the wall. To do that, the main contractor got 7 of its men, and they all stood on the staging that had been erected by CG. And then the staging collapsed and injured several of the people on the staging and killing the plaintiff's husband. The plaintiff brought a claim under the fatal accidents legislation that was in force at that time. And it was found that there was a defect in the staging. So that meant that the main contractor and CG were both liable to the plaintiff. And there was a 25-75% apportionment. So you've got the main contractor are liable for 25% of the damages payable to the claimant. And they sought to make the subcontractor pay for those damages under a contractual indemnity clause. That claim failed because the main contractor was under a statutory duty to ensure that the staging was of good construction, suitable and sound material, and of adequate strength. Because they were in breach of that statutory duty, they were not entitled to recover under the indemnity clause, because it wasn't to be construed as requiring the subcontractor to pay for things caused by their own negligence. However, an alternative claim under simple breach of contract was successful. So they also sued the subcontractor for breach of an implied term that the staging would be of sound construction. And that wasn't defeated by the Canada Steamship principle. The main contractor's breach of duty didn't break the chain of causation, and so they were able to recover the full loss that they had to pay to the claimant. Quite a similar case on different facts, but similar scenario was AMF International and Magnet Bowling Limited. This was a property damage claim. Claimant was installing bowling equipment at first defendant's building, and the second defendant was a contractor in the process of constructing the building. The claimant's equipment was damaged by water ingress into the building, and both the first defendant, the owner of the building, and the second defendant, the contractor, were held to be liable for that water ingress. The first defendant sued the second defendant under an indemnity clause, and that claim failed for similar reasons under the Canada Steamship principle. The damage occurred due to the first defendant's negligence, and so that indemnity clause was not to be construed as requiring the second defendant to pay in those circumstances. But like the previous case we looked at, there was another claim made under simple breach of contract, and that claim was successful. The final case that we're going to look at is Greenwich Millennium Village and Essex Services Group. This is a really helpful case to have a read of, because it goes through this entire line of authorities, and it's got an interesting analysis on scenarios where the negligence of the indemnified party amounts to nothing more than a failure to notice or to spot the earlier negligence or the earlier poor workmanship of someone else, or of the indemnifying party. So the parties were all involved in constructing two ginormous blocks of flats on the Greenwich Peninsula. And the two parties we're interested in were HS Environmental Services, and they were a specialist subcontractor. And then there was Robson, who were contracted by HSE, and they were responsible for installing the pipeworks. HSE's contract with Robson contained a clause requiring Robson to indemnify HSE, very broadly put, against liabilities arising out of Robson's negligence or their breach of contract. Now, the water main tanks were in the basement, and so all the water had to be pumped up these vertical pipes all the way up the building. If the water's pumped up at excessive speed, it forms what's called a water hammer, which puts too much pressure on the pipe, and it could lead to a burst pipe. And that can happen when there's a vacuum in the pipe, because all the water rushes up and then punches a hole in the pipe. So what Robson had to do was install the valves in the pipes with a surge arrestor, so that it prevented these vacuums from from occurring in the pipes. But Robson put all the valves in the wrong order, so that meant that the surge arresters didn't work. And what happened was the tenants moved in, they started using their showers, started using their taps, and then a huge flood occurred in one of the blocks. And the judgment describes water escaping and then streaming through the flats and then cascading down the sides of the building. So it sounds all rather dramatic. The judge found that the principal causes of the flood were workmanship failures on the part of Robson. So it was their negligence that caused this all to happen. Greenwich Millennium Village brought proceedings against two of their contractors for breach of warranties, and then, as we're all familiar with, there followed a cascade of proceedings under CPR Part 20, with the various contractors seeking to pass on their liabilities under various contractual indemnity clauses. At first instance, Mr. Justice Colston found that HSE could pass on its liability to Robson for the entirety of what it had to pay. On appeal, Robson argued that HSE had negligently failed to detect and address the issue with the valves. And so because of their negligence, because the loss could, in one sense, be said to have occurred because of their negligence, as well as Robson's, they weren't entitled to recover under the indemnity clause, under the Canada Steamship principle. That argument, in these particular circumstances, was rejected. And this is what Lord Justice Jackson said. It would largely defeat the commercial purpose of the contractual chain if failure to notice prevented the indemnity clauses from operating. The participants in building projects arrange their affairs to take out insurance cover on the basis that they're likely to be held liable for shortcomings in their own work. In the case of a construction contract, a failure by the indemnity to spot defects perpetrated by its contractor or subcontractor should not ordinarily defeat the operation of an indemnity clause, even if that clause fails expressly to encompass damage caused by the negligence of the indemnity. And he drew a distinction between positive acts of negligence, so something the party seeking indemnity has actually done that has caused or contributed to their damage, or perhaps a more serious omission might fall into that category, and cases where it's simply a failure to spot or detect a defect that they should have spotted. And in the latter case, certainly in the construction context, Lord Justice Jackson was saying that a simple failure to spot shouldn't prevent a party from recovering under an indemnity clause. So we've been through the cases on the Canada Steamship principle, and we've seen that ordinarily if a party's negligently caused damage, that would be a bar to their recovery under an indemnity clause, unless there's very clear language indicating otherwise. But one point that I just thought worth highlighting from some of these cases, and you probably noticed them as we went through, is that even if an indemnity clause doesn't provide for a successful right of recovery, there is still an alternative claim under breach of contract. So in the Magnet Bowling case and Sims and Foster Wheeler, claims under the indemnity clauses failed under the Canada Steamship principle, but there were alternative claims in ordinary breach of contract under which the claimants were able to claim 100% of their losses that they'd have to pay out. And this was put particularly clearly in the Greenwich Millennium Village case at paragraph 98. It says negligence by the indemnity which prevents the operation of an indemnity clause need not shut out an alternative claim for breach of contract. In that scenario where you're saying, okay, we may not be able to claim under this indemnity clause because the loss is caused by our own negligence, but we want to sue this party for breach of the implied term of reasonable care and skill. The question really becomes, was the principal's negligence sufficient to break the chain of causation for the contractor's negligence? So if they did something significant after the contractor's negligence, which either was the true cause of the loss or greatly it increased the extent of the loss, that might break the chain of causation and that might prevent recovery of the full sum. But in many cases, even if they have in some way negligently contributed to the loss, it won't be enough to break the chain of causation, and they'll be entitled to recover the full sum on a breach of contract basis. One thing to be aware of is that even if it's a breach of contract claim, when you're dealing with implied duties of reasonable care and skill, there might be a possible reduction for contributory negligence under this case, important contract case, but I'm just going to call it Vesta and Butcher. If we briefly return to our example, you'll remember that the indemnity clause required BB Builders to indemnify Acme against losses, claims, or liabilities arising out of performance of the services. And we were asking, what if BB Builders were responsible for inspecting and preventing dangers on the site, but actually the cause of the upturned plank was Acme's own negligence? Would Acme be able to pass on their liability to the person who sued them to BB Builders under this clause? And the answer is probably not, because of the operation of the Canada Steamship principle. It was Acme's negligence that caused the loss. And so applying that principle, it's very unlikely that the parties intended Acme to pass on that responsibility for its own negligence to BB Builders. And certainly there's no clear language to that effect in this clause. So I hope that's been helpful, a broad overview of these contractual indemnity clauses, principles of construction that apply to them, and some consideration of arguments that you might encounter as to whether things fall within or outside the scope of them. I should have said at the start, there's a Q&A function. And I can see I've already been asked one question, but do feel free while I'm attempting an answer to Neil's question to type any questions that you have. Otherwise, I'm always at the end of the phone, and I'm very happy to take questions by email, whether it's on the topic of this particular webinar or it's something that you're working on and could informally do with bouncing something off someone. I've been asked a question by Neil Russell, which is what's the court's position on costs when the claimant didn't succeed on the main indemnity claim but succeeded on breach of contract? Well, we're not told in the law reports, but undoubtedly it would be the starting position would be that if there was a successful claim, that party is the successful party. So usually the successful party is the one who's been in receipt of the money. So whether they've recovered under one head of claim as opposed to the other isn't usually such a relevant factor. It's at the end of the day, have they recovered the money from another? And if so, they would be entitled to their costs. That can be subject to an issues-based costs order, but I doubt that would really be a route that the court would want to go down if there's a claim based on the same subject matter, just on different bases. I've been asked another question. Where indemnity provisions include bearing the injured party's legal costs, litigation ensues, will the injured party be able to be liable to indemnify 100% of the costs, or would costs still have to be assessed if they're not agreed? I think that would be a question of construction of the contract. I've never dealt with a term like that, but my hunch would be that the court would be pretty suspicious of an interpretation that was saying that any legal costs, no matter how unreasonable, would be covered by this indemnity clause. I think they'd want pretty clear wording if that was to be the effect. So I think probably the stronger argument would be that it's 100% of reasonable costs would fall to be indemnified by the party. But as I say, there's no general principle to that effect, so it's a question of construction based on the principles that we've considered in this webinar. Well, unless there are any other questions, that's all from me. Thank you very much for joining me.